today we bring two assignments of error. The first is ineffective assistance of counsel, and the second is a failure of the evidence with respect to the spitting on police officer counts. With respect to the first assignment of error, ineffective assistance of counsel, as the court is well aware, and I wouldn't normally go over this, but we do have people in the gallery today. It's controlled by Strickland versus Washington, and the primary consideration there is where the trial counsel's failure is falling below an objective, reasonable standard of representation, and that failure prejudiced the defendant. Excuse me. In the instant case, the complaint that the appellant has is that his trial counsel is the only lawyer to ask any questions with respect to the threats that form the basis of the disorderly conduct charge. Specifically, on page 97 of the transcript, we find the defense attorney asking the only questions about threats having been made. This testimony goes to the element of disorderly conduct and was ignored by the state up until that point. Had the lawyer not asked the questions, there simply would have been a failure of evidence on that issue. But for counsel's failure, the case would have been different because there would have been a failure of evidence on that element. My colleague cites a couple of cases that I did want to address in his brief. Specifically, he cites this court's authority in State v. Smith and State v. Diaz to the proposition that cross-examination is essentially off limits with respect to a claim of ineffective assistance of counsel. I think that's a misreading of those two cases. When you look at the Smith case was talking about decisions regarding cross-examination of an expert witness, of a witness, and that the appellant was unsatisfied with the nature and the extent of the cross-examination. That's very different from the cross-examination developing the actual affirmative evidence of the offense.
But the state replies in their brief that there actually was prior testimony.
There was some prior testimony that elicited hearsay relative to the threats, but the only affirmative evidence of threats was developed cross-examination by the defense attorney. It's for this reason that we think that that's distinguishable from the Smith matter. Now, with respect to Diaz, the Diaz case also deals with cross-examination of an expert witness and the development of the cross-examination, which we believe is inconsistent with the idea that they failed to bring the underlying evidence. So here, the defense lawyer actually brought the only competent affirmative evidence of the threat that constitutes the disorderly conduct. For that reason, we believe it's ineffective assistance of counsel, and I believe you should reverse. In the second assignment of error, this is a failure of evidence with respect to spitting and the question of whether that caused annoyance or concern by the police officers who were allegedly spitting. The statute requires that there be a showing of that there be a showing of annoyance or harassment, an intent on the part of the defendant to cause distress on the officer who is the subject of the spitting. When you look at the testimony of the two police officers and the EMS worker who responded, you will see that Marjack said that he didn't like the spitting, but he didn't say that it harassed him or annoyed him. It just that he didn't like it. And if you look at the testimony of Comley, he said that that was a spit that landed in the middle of a group of people. He wasn't even sure that it was directed at any particular individual. And then the last officer, the lieutenant, I believe was Giardini, testified that he was spit on his vest. And the prosecutor asked him if he wanted to be spit on, and he said no. And the prosecutor asked him if he asked to be spit on, and he answered no. But in either case, he asked him whether he was annoyed and harassed by that.
Can't it be presumed that somebody
officers and aggravation on the part of the defendant. So while I think you might draw that conclusion, I don't know that that's appropriate for it to be drawn without it being in the record. So there's nothing in the record that says they were harassed or by this litigation.
But just as the jury instructions go, if it snowed, you know, if you go to bed and there's no snow on the ground and it's dry land and you wake up and there's snow all over the place, you can snow and you can really snow during the night.
Well, sure, that's the inference instruction, but the difference there is that the snowing is the operative factual element that needs to be established. And so the seeing of the snow on the ground leads you to the logical inference that there was precipitation. On the other hand, here you have an officer who said, oh yes, the spit got on my vest. But that's not less necessarily a logical inference that it follows from there being some spit on his vest that he was annoyed or harassed by that. And the statute is trying to punish the harassment of the bodily substance, not necessarily the fact that a bodily substance touched a police officer. If there are no other questions from the panel, I'll read this down. Thank you.
Thank you.
Good morning, may it please the court, on behalf of the state of Ohio and Lorain County Prosecutor J.D. Tomlinson. Looking towards appellant's arguments with regards to ineffective assistance of counsel, I understand he tried to, not going to recite Strickland v. Washington, but obviously looking to the objective standard measure there. He tries to distinguish Diaz, and those cases also hold up the standard that trial counsel is presumed competent, and that generally debatable trial tactics such as cross-examination will not constitute ineffective assistance of counsel. Cross-examination being typically one of those. So that's where I would say he's not met his burden with whether or not the trial counsel fell below an objective standard. But let's say he did, I would not say that Mr. Callahan was at all prejudiced. I think one thing that needs to be very clear here is appellant keeps saying that Callahan had to show threats for disorderly conduct, but that's not the statute he was charged with. If he was charged with 29-17-11-A1, he would have had to make threats. But he's charged with 29-17-11-B1, which states, no person while voluntarily intoxicated shall do either of the following: in a public place or in the presence of two or more persons engage in conduct likely to be offensive or cause inconvenience, annoyance, or alarms to persons of ordinary sensibilities, which the conduct of the offender, if the offender were not intoxicated, should know likely to have the effect on the others. As in the brief, Officer Marajek, Lieutenant Giardini all testified that they could smell alcohol on Mr. Callahan. He appeared intoxicated, he acted intoxicated. Ultimately, they arrive on the scene, and Mr. Callahan is confronting the bar patrons outside the bar because he wouldn't go in the entrance. He had to jump over the fence because he thought he was cool or something, which the people at the bar said, no, you have to go through the entrance. Mr. Callahan didn't want to do that. He then got in a fight with an individual because he was wearing a Bass fishing shirt because he thought that was racist and insulting to someone. He then spit on that patron. Eventually, when the police arrived, they had to take him aside. He's continuing to fight, argue with the police. They say, we just want you to go home, but he won't go home. He won't even give them their name and say, hey, we'll give you a ride home. Eventually, he tries to walk away. They stop him. Also, unfortunately, Mr. Callahan only has one leg, so his leg fell off, his prosthetic leg, which then caused issues. He then is on the ground. He's continuing to struggle. He's spitting on him. They had to put a spit hood on him there. They had to put a spit hood on him in the hospital. So with regards to ineffective assistance to counsel, I would say, Your Honors, that the trial strategy of this cross-examination was not the only evidence that fell below an objective standard. Based on the statute for disorderly conduct, there was more than enough evidence from Mr. Callahan's own testimony, the body cam videos, and testimonies of the officers. Any of the evidence that would be hearsay competent or our understanding of the trial factor to discern the different evidence. Now, with regards to the sufficiency of the charge with regards to harassment of bodily substance under 29.1.3.8b, Mr. Callahan only is challenging whether or not he acted with the intent to harass, annoy, threaten, or alarm by spitting on the police officers. It seems from appellant counsel that issue is only whether or not someone felt harassed, not whether or not they intended to act to harass. And I would say, citing to some of the case laws, particularly the State v. Lundy, the intent of an accused person is only in his mind and is not ascertainable by another. It can only be proved by direct testimony of another person, but must be determined from the surrounding facts and circumstances. There's also, we would say that circumstantial and direct evidence have the same probative value here. As I reiterated before, Mr. Callahan was upset about his confrontation with the bar patrons. He was then upset with his confrontation with the police. He was spitting on everyone. Obviously, the indictment was just towards the police officers with harassment, but there is no evidence that just saliva was falling out of his mouth. He just wouldn't stop spitting on people. So for that, Your Honors, we believe that there was more than enough sufficient evidence from the record, the testimony, Mr. Callahan, the testimony of the officers, the EMT worker, and the body cam videos. Thank you for your time.
Thank you, counsel.
I only have one brief matter of response to comments.
I was going to say you have a full 5 minutes.
I won't need them. But in any event, the question of whether this is the intent or the perceived reception of this action, and whether that makes a difference between harassing, annoying, threatening, or alarm. Mr. Callahan testified that he didn't intend to spit on anyone. So if we're going to go solely by intention that can only be determined from Mr. Callahan's mind, then the answer to that is he didn't intend to spit on anyone. But having said that, I think it's the question of how it's received evidences or allows you to draw the inference about whether the person felt harassed, annoyed, threatened, or alarmed. None of the people that responded testified that they were in any way alarmed or harassed by this action. As I said earlier, Marjek said he didn't like it. That's the only thing he said about it. Comley, who's the EMS worker, said that the spit landed in the middle. He wasn't even sure who it was aimed at. And finally, Giardini testified that he didn't ask to be spit on. But none of those things go to, I'm sorry.
No, you can continue.
Oh, none of those go to the idea that he was trying to harass, annoy, or threaten.
So was his testimony as the prosecutor, as the state just said, that it should fall out of his mouth?
Well, there were two different areas of testimony on that subject. Callahan testified that he didn't spit on anyone, so he flatly denied. And then the EMS worker said that there was spittle coming from his mouth within the context of his shouting. And then in a different portion of his testimony, Comey also said, but yeah, he spit on my mouth. So from those facts, I would conclude that Callahan was angry. He was being restrained against his will, obviously. He was being restrained, and he was being increasingly agitated by the escalating use of force, including the placing of a spit collar on him. As a result of that, his behavior escalated as well. But in any event, he didn't harass or annoy anyone by his own testimony.
Is there audio with the body and video?
There is.
And does that capture any of his spitting activity?
No, I think the first officer testified that his body cam didn't capture anything that had happened. He saw it off camera. So the body cam obviously